Any mention?
May I please, Your Lordship? I beg to mention item number 9 and 10, Your Lordship. I pray for 2 weeks' time, Your Lordship.
No objection, Your Lordship.
Highly obliged, Lordship.
May it please Your Lordship, I beg to mention item number 15. Praying for 3 weeks' time, Your Honor, Your Lordship.
You are appearing on behalf of?
The petitioner.
Other side?
They are Guwahati Council, Your Honor.
Have you informed them?
Yeah, we have informed. We have informed, Your Honor.
So when do you want it?
After 3 weeks, Your Honor, Your Lordship.
3 weeks on the prayer of the petition. Okay.
Highly obliged.
I beg to make a mention of item number 11 and 12. In 11, I am for respondent number 3, and in 12, I am for respondent number 2.
And who is the petitioner here?
Mr. S. D. Lordship.
Have you informed them?
Yes, yes.
Where are they?
They are just here just now, Lordship.
You are the petitioner.
You.
Your Lordship, Mr. SD is for the petitioner.
Yes, whether he has been informed or not, that is the main thing.
Yes, yes.
See, Mr. Dev is there. Yes, Mr. Dev. Your matter has been mentioned.
No, I'm not dealing with that matter presently.
Okay.
Pray for some more time, Lordship, to file my affidavit.
Yes, item number?
11,
Is it
12.
Connected matters?
Yes, sir.
Yes, sir. 2 weeks. On the prayer made on behalf of the husband. Yes.
Lordships, I beg to make a mention of item 13 on behalf of Mr. A.S. Pandey Manoj.
Yes. Here who is appearing for the respondent? Again, Mr. De. This is also not Mr. Dev matter. Is this not a matter? Please come. Don't talk. When court is talking with you, at least.
I was there earlier, but now
Okay.
I'm not.
Right now we are not. Yes.
My friend is there, I think. He's
It's all right. It's all right. There is no problem.
I'm sorry.
Because you argued this matter
Earlier,
at
no.
some length, isn't it?
Lordship.
Yes. Okay. So, okay.
2 weeks, my lords.
No objection.
2 weeks.
Grateful, my lords.
Yes.
Highly obliged.
Yes.
Item number 1.
This is again a criminal revision.
My lord.
What is this case over? Again, you are
My lord, charge has been framed under 30234.
30234.
My lord.
And this revision is against what?
Framing of charge.
Even in 302 also. Yes.
Yes, my lord. Yeah, this is a criminal revision petitions against the order passed by the session court, my lord, by the Meghalaya district. And then we have filed this revision for order rejected by the
Your
at the
discharge was, your
consideration
prayer
of
for
judge.
discharge was rejected. Isn't it? Now here the offence alleged against you is 302-34 IPC.
Yes,
isn't
my
it?
lord.
Now what is the ground on which you are seeking discharge?
My lord, at the time of framing the consideration of charge, there was this case was related to 302 and 34 IPC, my lord. At the time of consideration of charge, there was no material evidence against the complainant, against our.
There is no
petitions.
material evidence.
Yes, my lord.
Nothing. So why you were implicated here?
My lord,
There is no FIR.
FIR. I'm the petitioner is the one who filed the FIR, my lord, who filed the complaint
Okay.
against that. I'm the one who filed the complaint, my lord, and filed the FIR regarding that my husband has been murdered
Okay.
by the three persons, my lord, while they are traveling.
You were traveling together.
Yes, my lord. Me and my husband, we are traveling together.
Okay.
And then
Your husband was murdered in front of you.
No, my lord.
my lord,
She was, according to her, my lord, she was chased away. She was not wanted.
Let her explain. Just give chance to them. Okay. Let them also encounter. Yes.
yes, my lord. They have threatened me to. They have blocked our road while we are passing, my lord.
Where you are going from where to where and by which means? You are walking on.
By
you are
car,
on-
my lord. We are traveling by car, my lord.
Okay.
From
You are traveling by a car.
yes, my lord.
And
And then suddenly
How many of you are there in the car?
two of us, my lord.
Only
Me and
so-
my husband.
So your husband was driving the vehicle.
Yes, my lord. And suddenly the three persons block our way.
Okay.
And then they stop the car, your honor. And then after that, when we come out, me and my husband, when we came out from the car, they have threatened me to go away, and then they have.
You went. You
Yes.
went the threaten and you left.
No, my lord, I have reluctant, but then they have threatened.
So the incident did not take place in front of your eyes.
No, my lord.
Now thereafter when this incident took place?
On 11/12/2021, your my lord.
And when did you file your FIR?
On 13/12/2021.
Okay. And then why it took so much of time for you to lodge on FIR?
My lord, during the time when the incident happened, it was during the night time, my lord. And then when they
Even
threatened
then
me,
there's a gap of 1 day, isn't it? 11
Yes,
and
my lord.
13.
We have already after the when they threatened me, I went to the village to inform to the to the headmen and all. And then after that, when we came back on the morning time, along with all the villagers and all, they
But
have.
then what happened for the 1 day? See, there is a gap of 1 day. Your husband died. It's a
Yes,
very
my lord.
serious offense. Isn't it?
Yes, my lord.
Anyway, then tell us what the FIR says, what the investigation revealed. Why you were arrested?
My lord, there is a counter FIR
By?
by me, by the my husband, my sister-in-law.
Okay, your husband's sister.
Yes, my lord.
And what the counter FIR said?
That I am included in this murder.
But let it be proved at the trial. You cannot say that there is no materials at this stage.
My lord, but then there is no in section 1.
See, there is a FIR, counter FIR you can say,
Yes, my lord.
and then it was investigated upon. Isn't it?
No, my lord.
Police just filed a charge sheet.
My lord, the police they have investigated they have
Your very
investigated after.
conduct of remaining silent for more than 24 hours is very, very suspicious. If that had happened and you were left, you should have landed up in police station instead of going anywhere else. This itself is a very suspicious situation.
But then there was no material fact. at the
Yes, what shall you do?
consideration of judgment.
My lord,
Any purpose will be served by issuing notice.
no, my lord. The fact remains, my lord, this is a case, my lord, where she files an FIR belatedly, my lord. Subsequently, my lord, another FIR, counter FIR is filed, alleging that the wife, that is the petitioner herein, was having extramarital affair with the person who murdered the husband, my lord. And in 164, she has confessed.
So she is not the only accused in a case.
Yes, my lord.
No, ma'am.
There are some more.
Yes,
more
my lord, the lover of this petitioner had absconded, my lord. And later on it was apprehended. They have confessed also, my lord. So, my lord, at this juncture, my lord, framing of charge, my lord, prima facie, my lord, at a cursory reading of the evidence, my lord.
You know, proposition of law is very well. If you say this acceptance of the entire materials on record will not make out a case, then we agree. But then if it is not, then and there appears to be a direct, clear-cut allegation against you.
But then there was no material evidence that.
What do
that I
you
am
mean
the
by
one.
material evidence?
That will come during the trial.
What do you mean by material evidence? If you say material evidence, what do you mean by material evidence? That the weapon or this, that and all, do you say that is the material evidence?
That one also material evidence. It includes that one also.
I do not know. So, you want this court to pass some order? Problem. Why you come in this kind of cases? You know it very well. Who is your senior here? Are you led by any senior?
Yes, my lord. HR not. He is on sanction leave, my lord, right now.
Issue notice, you will see on the next day. Halt. Issue notice returnable in 3 weeks. Mr. Gurung appears on behalf of all the GA appears on behalf of all the respondents. List after 3 weeks.
Deploy.
Just made a concession for you, nothing
Yes,
more than that.
yes, my lord.
Item number 3.
you will just say it like this, issue notice, then call for the records. Then you will say such and such APS for so and so. Okay? Then list of proceedings. Just line has to be before and after.
Your Lordship, the conducting counsel is unable to come today. He'll be present tomorrow, so the matter may be.
What case
taken
is
up.
this?
It's a CRP case. Your
What is that about?
It's for the miss case to be disposed of.
Who is the lawyer appearing here?
PK Bora, Mr. PK Bora.
When?
Tomorrow?
On pre-armed by Mr. PK. On behalf of Mr. PK.
Obliged to you.
Hearing item number 5.
Kindly list this matter at the end of the board. Kindly list the matter at the end of the board, Your Honor.
The end of the board.
My lord, I have certain difficulty. I have some matter in the single before CJ, my lord.
What shall we do?
You'll start, sir?
Already.
Okay.
There was some instruction upon the state as well as the managing committee.
Just on pre-armed with the parties, list after a week. Yes.
Deeply obliged.
Item number 6.
May I please, Your Lordship? Lordship, learned DSJ is on legs, Your Lordship, for division bench. Praying for some accommodation, Your Lordship.
You be here, let him start.
Yes, Your Lordship.
These matters were heard by a bench, by another bench also before, isn't it?
My lord.
There appears to be no. These are part-heard matters actually, should not have come up before this court. Yes. What is this? Anyway, just give us factual background.
My lord. My lord, the petitioner was enrolled in Assam Rifle, my lord, as a rifleman nursing assistant. On 28th December 1987, my lord.
Where is the order? Where is the order of enrollment?
My lord.
Where is the order of enrollment? When? Where it is? Have you
Order,
annexed it?
Everment is there, my lord.
There is no, you have not annexed any document.
My lord, that documents.
Which paragraph?
My lord, para 2 itself, my lord. Page 4 of the writ petition, my lord.
December 2000, 1987.
1987, my lord.
Yes, Havildar.
As a rifleman, my lord. As rifleman nursing
Yes,
assistant.
Yes, Havildar, what is NA? What do you say in paragraph 2?
In nursing assistant, my lord.
So there is no mention of any rifleman and all this thing. You have different trades, isn't it?
My lord.
Now, if you are in the nursing trade, how can you be a rifleman then?
My lord, rifleman is a common, my lord. Initial rank is a rifleman, then Naik, my lord. Naik and Lance Naik was abolished by the, it has been merged. So directly from rifleman to Havildar, my lord.
Now, you say here is Havildar, so where again rifleman is coming? See that you see, like this court will have to mention it while writing judgment. Now you are saying that he is rifleman, your affidavit says that he is Havildar. As Havildar, nursing assistant. So, it's contradicting your own submission.
It's a rifleman, my lord.
We cannot go beyond what is said because you have not annexed any document. If you had annexed also, we could have overlooked that. That is a problem.
At the time of enrollment, my lord, there is no documents which is.
At least you know what rank. You mention one rank in your petition and your submission you are saying another rank. Yes, madam, can you clarify anything on that? No.
Your Lordship, first he was enrolled as a recruit for nursing assistant. Then in 1987 there was an existing vacancy for a rifleman nursing assistant. So he was recruited in that vacancy.
So it means whatever is stated in his petition is not correct.
Your Lordship, he was promoted to that rank of Havildar of nursing assistant,
So he has never been enrolled there at the beginning, isn't it?
Your
He
Lordship,
got that post after promotion, isn't it?
he was enrolled first as a recruit. Then this rifleman, there was a vacancy
What
in
you will say
1987.
about his statement in paragraph 2 of the writ petition, that means that is not correct, isn't it? If you are saying something else, that means his statement is not correct here. Now you see your list of dates. You say only petitioner was enrolled in Assam Rifles. NA, nursing assistant. See, column 2 of your list of dates which you have just now, synopsis of argument just now which you have submitted. There also you do not say anything about post. Now which way you want this court to decide it? If it is a matter for upgradation, okay, at least for benefits under the MSCP scheme, then those will be relevant. Whether you are promoted or not promoted, that there has to be a clear statement of that. These are basic facts, Mr. Jha. He was appointed as what, according to you?
Your Lordship, in our affidavit in opposition, and page
Has it
6.
been mentioned?
Yes, Your Lordship.
Have they filed a rejoinder against your affidavit in
Yes,
opposition?
Your Lordship.
Whether that part of the statement was refuted there? Was there any rebuttal?
Page 2, para 2A, my lord.
You see, Mr. Jha, see, this way, it's a problem. The court will not conduct a research for you to find out what post you have been appointed. Do not expect that much from the court. That is for you to come and say. So he was never appointed as Havildar. He was a rifleman, nursing assistant,
Yes,
according as per
He
your.
was a recruit first, Your Lordship. In para number 5, page 6, we have replied to the statement in para 2 of the petition.
Yes.
In paragraph number 6, Your Lordship, we have stated that with regards to statements and averments made in paragraph number 2 of the writ petition, the deponent denies the same and states that the petitioner was enrolled in Assam Rifles as recruit nursing assistant on 28/12/1987.
Recruit, what is meant by recruit nursing assistant? And what is made by a rifleman nursing assistant? What is the difference between these two? These are not entry level posts.
No, Your Lordship, they're not similar.
You will not be able to
posts.
say that. Yes.
Rifleman is a entry level post, my lord.
And what about what you say?
Rec-
Rifleman is an entry level post. But then you say you have been you joined us. What you read out just now, Ms. Falcon?
Lordship, petitioner was enrolled in Assam Rifles as recruit nursing assistant.
So what is recruit nursing assistant?
Recruit is who goes for the training, my lord.
How you find it out? You're making, see, you say that you have been enrolled as recruit nursing assistant. They say you have been enrolled as rifleman nursing assistant. So there appears to be difference. How do we resolve this difference, and where do we get it?
That's, my lord, that recruitment rules.
Yes, show us where it is. Clarify it. You have to show that this is one and same.
My lord, can
Where it is?
my lord can come to page. Page 8 of the affidavit in opposition filed by the
By the state.
page 8, para 11 now.
Yes.
My
Yes.
lord, A is a
Where is the mention of that recruit nursing assistant?
recruit nursing assistant, my lord. Recruit is it's a common, my lord. Recruit nursing assistant or recruit clerk. There is no mention of any recruit term as per the RR recruitment rules of 2000.
See, you see, the problem is that in their affidavit they say that you have been appointed as rifleman nursing assistant. Now, in your response to their affidavit, you revert their statement and you say that you have been appointed as recruit nursing assistant. So there appears to be a difference. Otherwise, what is the question of yourself reverting their statement? Explain us. This appears to be very confusing to the court.
As per the recruitment rules, my lord, these are the nomenclature which a person of 2001. Rifleman is the initial rank.
Show us there where that nomenclature, that recruit is prefix recruit is used where and till what stage? Is it something like that by saying recruit you remain as a trainee and after completion you become a full-fledged rifleman? If that be so, also you clarify it. We cannot say anything on assumption. It is you have reverted their statement. Otherwise, there is no problem. We can say that yes, you have been enrolled as rifleman in nursing assistant. But then you say you have been enrolled as a recruit.
My lord, I did.
Your petition says that you have been enrolled as Havildar.
Your Lordship, recruit would be in the year 1987. He was attested as a rifleman on 30th January
So
1989.
that means after confirmation, that is what, isn't it?
Yes, Your Lordship.
That is what this court is looking for. Then where from we get it? Just tell
Your
us
Lordship, in our affidavit in opposition.
where it is.
Page number 6, paragraph number 5, Your Lordship.
Point it out. You have to. You're asking for it for so long. Paragraph number?
5, Your Lordship.
No, nursing assistant. Is that correct? Have you seen?
My lord, that's it's correct.
Are you
That's
sure
what-
that is correct?
That's
What is the
what-
response to this paragraph, madam?
Your Lordship, in their rejoinder affidavit, in paragraph number 7, page 3, they have responded to this, that with regards to the affirmance made in para 2A of affidavit in
No,
opposition.
do not say it is. You are mentioning para 5 now. You have pointed out to para 5. So what is their response to para 5? No, she is now trying to clarify the case for on your behalf. That should have been your duty, and it seems like that you have not gone through the averments also properly.
Your Lordship, in paragraph number 17, they have replied to
Okay,
this.
what have they said?
They say that the answering deponent admits the contents made thereof being
We have
matters
not
of
denied,
record.
That is okay. So this is what is reflected at page para 5 of your affidavit in opposition. So your first position starts at rifleman nursing assistant,
My lord,
isn't it?
my lord.
Yes. What are the posts in the hierarchy?
In the
Next higher post?
next higher post is a Havaldar, my lord.
Okay, then thereafter?
Thereafter, Naib Subdar.
Okay. Then
Then Subedar and Subedar Major, my lord. Subedar and thereafter Subedar Major.
okay. Yes. Now tell us. Now
87.
you are still in service? What position you are holding now?
Now I'm a Naib Subedar. No.
It means you got 2 promotions. Isn't it? From rifleman to Havildar and to then Naib Subedar. Now SCPS, MSCP makes you entitled for 3 upgrades.
3, my lord.
Yes. Did you file representation before the authority?
No, my lord.
You have approached this court directly
My lord.
without filing any representation. You do not want department to consider your case.
We want definitely, my lord. We wanted.
No, this normal thing is that when your department refuses, then only you come to court. Court is not a, forum for redressal at the first instance.
My lord,
You have not even approached your department also. Saying that yes, I am entitled for this thing, please allow me, grant me. Moment they refuse, you come. Are you? Just so. Yes. What was your pay scale when you joined?
my lord, at the
These are your pay scale basically is revised from time to time
my lord,
on the basis of what?
on the basis of my lord, notification as well as the on 10th of
So far as the revision of pay is concerned,
my lord, that's pay
in
commission.
which manner it takes place here?
Here, my lord, by way of 6th pay commission. Prior to that, my lord,
Okay, so
Pay
basically
commissions.
CCS rule.
my lord,
That is the upgradation is basically CCS.
Yes, yes.
Now, the time when you joined, 87, it means probably fourth or third CPC was in force.
At that point of time, my lord, 87, fourth pay commission was there.
Fourth paper commission. Now, what was the, now it is seventh. Now, please tell us what was the pay scale, your pay scale under fourth CPC, and give corresponding revised pay scale also under seventh, so that we can decide whether you have been given upgraded pay scale or not. This when this MSCP came into force?
My lord, AC, first the ACP
ACP came in 99.
99.
MSCP 2009.
9.
2009 or 10? 2009.
With effect from, it came in.
Okay. Now, before SCP, was there anything prevailing for upgradation? No. There was no scheme.
No, that was, my lord, in between, that was 10/10/1997, my lord. 10th of.
Before SCP, SCPS came into force. What was there any scheme prevailing? SCPS came in 99,
my lord.
guaranteeing 2 upgradation after 12 years.
My lord.
Then it was subsequently replaced by MSCP,
MSCP by
guaranteeing 3 upgradation every 10 years. First 10 years, second 10 years, third 10 years, isn't it?
My lord.
Now, you joined in 1987.
87.
Now, it means since there was no scheme, so there was not guaranteed upgradation. Now, 87 you joined as a rifleman.
My lord.
Now, one thing, if you go by paragraph 5,
My lord.
your paragraph 5 of their affidavit, isn't it?
My lord.
Now, for your computation of period, whether in 1987 has to be taken into consideration or 1989, because 1989 you have been attested as rifleman nursing assistant. Now, for calculation of 10 years,
My lord.
what will be relevant, 1987 or 1989?
That will be 1987.
On what basis you say?
My lord, because the date of joining, my lord, even as a recruit is within the training period, during the training period.
Then what happens if a person says, supposing
My lord.
a recruit is not confirmed, then what happens? Whether his date of joining will remain 87 like that?
If he is not confirmed or attested, my lord, that's attestation word.
Attestation means what? Confirmation only?
Confirmation.
Yes.
But the date of
See,
joining.
your date of joining will be taken from the date of attestation or from the date of the recruitment, date of the very joining in the service.
That will be taken from the date of.
Okay, but then the thing is that if it is from the date of enrollment,
My lord.
that means the fact remains that whenever you join in, that becomes your enrollment, isn't it?
Date of
It cannot be from the date of attestation. It has to be date from the enrollment.
enrollment.
Is that correct? Can you say? You will not be able to tell. Okay. Yes. Okay. Let us take it at 87. Then, what happened when you got your first upgradation or promotion, whatever you say?
My lord, the petitioner is seeking the first financial upgradation, my lord.
Which year? Seeking financial in which year?
28 December 1999. they are seeking.
After the SCP came.
My,
12 years.
my,
Isn't it?
my lord.
Now, when they gave you fast upgradation?
My lord, they gave the first upgradation in 2006, my lord.
Okay. Now there appears to be one confusion
My lord.
that there was upgradation in between, but then whether it is by way of pay revision
Or by
or by upgradation or by
notification
grant of,
dated
yes,
10-10.
that is what is the controversy, isn't it?
My lord.
That is why Dr. Mojiga perhaps on the other day he was pointing in out.
My lord.
Yes. Now that is why we must know your pay scale. Tell us what was your pay scale when you joined in 1987? Okay, and after revision under 5th CPC, what was that? Okay. Because you are saying that the pay revision took effect in 1997.
10-10-1997.
Yes. With effect from which date?
My lord,
Okay. Now give us what is the pay scale? What was your pay scale and what it was revised to? Mr. Jha, these are all relevant things. Until and unless you do it, then we cannot decide the matter.
my lord, those at that point of view, we could not, at the fourth pay commission, we didn't have the.
What is relevant is your pay scale. Upgradation has to be taken into consideration by seeking your pay hike, by looking at your pay hike, upgraded scale. So that is upgraded scale. Until and unless you do not show it, which way you will decide.
At that relevant point of time, my lord, we tried to get at that fourth pay commission pay scale, my lord, so that we could have annexed that.
No, but then that will be there, and that you see, this is in CCS payroll. It will be there. Everywhere you will find it in any records.
My lord,
When you were doing service law, that will be it should be readily available. Until unless you give it which way, you will decide. Just tell us which way you are proposing us to take a decision. Just tell us. We cannot merely go by your statement. You just tell us which way you propose to establish your case.
My lord, the pay scale which they are saying in their affidavit, my lord, that I have received or they have granted me the first financial upgradation, that pay scale itself in their affidavit does not exist, my lord.
So you show us what are the relevant pay scales. You can establish it by showing only pay scale.
My lord.
See, it is not a very tough work. You just take into consideration what is the existing pay scale under 4th CPC when you joined. Wait, what is the corresponding pay scale under 5th CPC, 6th CPC and 7th CPC now? Then similarly you come to your next step. In 2007, if you say that they have given an upgradation, so what was the pay under upgradation at that point of time? It was probably 5th or 6th CPC. 6th CPC, then it was revised to what? Under 7th CPC. That is only you have to give. And thereafter also if another upgradation is there, that also you show. So by looking at this corresponding pay scale, we can make out whether it has been given or not. Otherwise, how we will decide? You will assert, they will deny. Then? Now you say that your second financial upgradation under
SCP
2007 to 6,500. Was there any grade pay attached to it? Because probably under the
MSCP grade
6th pay revision, 6th CPC, I think grade pay was introduced. So pay scale 6,500 carried some grade pay. Probably. And if
grade pay of 2,800.
It was 4,200, 4,600, more than something like that. You see, one single pay scale may have many graded pay. And it even the grade pay also basically establishes upgradation. You may have one pay scale in a pay band of such and such with a grade pay of 4,200. Now, moment the same pay scale is conferred with grade pay of higher, say 4,200 to 4,600, that becomes upgradation. Now, that is how
Even-
you have to establish your case. You see, it will be very difficult.
Research has to be done, with a chronological. The
See, you say that your first financial upgradation under SCP scheme was 28 November 1999, previous kilo 5,500. 5,500, 900. Now, recently this court has come across a case involving the same pay scale channel. Same pay band actually, pay band 2. Okay. Wherein you'll find 6 CPC basically merged 2-3 pay scale into one pay scale. Like 5,500, 9,000. 5,000. There are 3 pay scale probably. 6,500, 10,500 also was initially merged. Subsequently, by a different notification, it was taken out of merger. Now that is where you can get things, details. We do not know what is the pay scale so far as the army is concerned, but then if you say it follows the CPC and it is a pattern,
yes, sir.
then you can do one thing. Probably recently in a division bench we have given a judgment, very few days back, concerning Nehu. Okay, and there were also cases of upgradation concerning the same pay scale. Okay, these are all pay scale categories under pay band 2. So far as this court remembers. So you look at that judgment, probably if it helps you in determining the corresponding pay scale. Mr. Shan had appeared in that matter. Nehu standing counsel. Or what? Or you can proceed as you want, but then I do not know. Your things are not at all clear. Your pleadings are not at all clear. This court will not be in a position to understand your case.
I will go through that judgment and come back.
You do not know whether that will be relevant or not.
Since it is the
But then court
the
has dealt with that pay scale. That is for sure. Okay, but then issue here it may not be similar. But then since we need to look at the revision of pay, probably that judgment may help you to some extent. Because this concerns same pay scale, 5,500, 9,000, 6,500, 10,500.
The pay scale which they are showing, my lord, 5,000 to that pay scale is not. I have
5,000? How? What pay scale they have shown?
they are showing, my lord.
Where do we get it?
My lord, in the affidavit, my lord.
Which paragraph?
Just
5,200.
2D, my lord, can come to
2D. Page 3, there is a tabulation.
Sorry, my lord.
Page 4, there is a tabulation of pay scales.
My lord.
Which pay scale you want to show us?
My lord, it's my lord can come to firstly page 2A.
2E.
2A. A, my lord.
2A, yes.
Yes, my lord.
Yes.
My lord, it's 5,200 to 20,200, my lord.
Yes.
My lord, that
Yes, 5,200, 20,200, it is not there in the pay scale, you want to say. 2,400.
My lord.
Now that pay scale,
My lord.
according to them, is under which pay commission? Under 6 CPC or 50 CPC?
That is, they are silent on that, my lord.
Yes, madam, can you tell us anything?
Your
Have
Lordship.
you taken note of that 5,200, 20,200
Yes, Your Lordship.
with great pay of 2,400, isn't it?
Your Lordship, in fact, the pay scales in Assam Rifles has been annexed with the affidavit in opposition.
Okay, where is
Type
that?
copies will be at starting from page 39.
Page 42 is the relevant portion.
Page 39.
Page 39 will be the starting of the type copies. The relevant page will be at page 41 onwards, Your Lordship.
Page 40.
1.
Revised scale of, then revised pay scale. Revised pay scale is what, under 5th CPC? 1997 is under 5th CPC, isn't
Yes,
it?
Your Lordship.
Okay. Then
5,200.
where is it? Is?
Nothing there, man.
No, 5,200. Yes, it is not there. See, Naib Subedar 5,000, Subedar 5,500.
Money.
Where is 5,200?
To 20,200, man.
This way a case cannot be conducted. Very difficult. Your petition is so not clear, nothing.
My lord, if I propose, my lord,
See, probably these three pay scale,
no.
this Naib Subedar, Subedar and Subedar Major.
Page 42, my lord.
Page 41, yes, page 41 of their affidavit.
My lord.
If this court is not very sure, but then probably these three pay scales were merged together into one pay scale under 6th CPC with a grade pay of 4,200. Now, subsequently, that pay scale of 6,500 was taken out of the merger and refixed with grade pay of 4,600. So, meaning thereby that it became an upgraded pay scale. Okay. Now, your matter also probably you do not know. It falls under these things because you yourself you are saying that you are placed under pay scale of 6,500. Second final, as second final is application. 2007, 28 December 2007. Oh, that is what your claim is, isn't it? You are claiming it.
I am claiming, my lord. That's. It should have been mine.
From 87 to 97, 97 to 2007, 2007 to 2017. There has to be 3 upgradations.
Three.
Whether by your promotion or by pay hike. Okay. Yes.
If I pray, my lord, that if I may be allowed to file a compilation of.
If you can file.
My lord. Additional by inserting the 4th pay commission.
You do not file any affidavit. You do not bring anything on record. just prepare a chart
My lord.
showing the corresponding pay scale. Starting point of 4th CPC when you joined. Okay, and this will not be a very difficult job. Okay, but then make sure that this CPC was applied to your case. Yes, madam, now you know where to basically just clarify on us that 5,200 per scale of 5,200, which has been pointed out.
Yes, Lordship.
That it is not mentioned anywhere.
Lordship, I'll clarify. Lordship, I'll
You
take
see, it's
instructions.
neither
and
under
clarify.
5th CPC nor under 6th CPC.
Lordship.
Okay, hard learning counsel of the parties. On prayer made by Mr. Jha, learned counsel appearing for the petitioner. This is matter after when?
2 weeks, man.
Please make sure these are the cases you have to come with those datas. If you come with those datas, it will be simpler to everyone.
Definitely.
This is matter after 2 weeks.
7.
2 weeks is okay with you? 2 weeks?
6 and 7, same one.
Same order. Same controversy.
Same. Nursing assistant, that is
Yes.
also.
Item number 8.
Yes, my lord. This matter pertains to the breach of an injunction order, my lords.
Yes.
So, coming from this honorable court specifically because Order 39 Rule 2A is no longer enforceable, my lords, because the rule clearly states that attachment order under this rule shall not be enforceable more than 1 year. So now it has reached
Attachment
almost
means
20.
what has been attached?
My shop, my lords, the Sue property.
Was there an order of attachment?
Yes, my lord.
Then
My lords, can I see page number?
shop is attached by after passing of the. There's an attachment provision of attachment before judgment,
Yes, sir.
isn't it? And implementation of injunction is one thing, and attachment of another thing, isn't
Yes,
it?
my lords. So can I see page number 108 of my petition, my lords? Because they have made an application for the breach of injunction order, so the trial court has passed this order, my lords.
Page 10.
108.
Is this a matter where you needed to file your power, Wakalatnama?
I have already filed, my lords.
So that should have been your first submission. That you have filed your power. Page 108.
Yes, ma'am. This is the
Yes.
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 Second paragraph, the OC of Lumdingji PS is hereby directed to enforce the interim injunction dated 23rd of 12th of 2015, 15th 2nd of 2019, which is still operable by ensuring that the same is complied with the opposite party, defendant, or any other person or persons acting on her behalf, and is further directed to submit the compliance report before this court on next day without fail.
Yes. Where is the attachment?
This is the attachment, lords.
How can this be attachment?
Well,
The law allows
lords.
implementation of this thing. Do you want to say that civil court has no? Are you trying to saying that this provision of attachment before judgment and the enforcement of provision for enforcement of interim order are same, one and the same?
No, lords. This is different provision, lords. So my shop has been closed. So someone's a form of attachment.
You see, what we see from here is only nothing. Implement the injunction order. Nothing beyond that. We are not going beyond that. It's a revisional court. We will not go into see what are things. Now, if you say that yes, court has said that it should be attached, but it's not that. The direction is only to the extent to ensure that interim injunction order prevails. Nothing else.
Lords, as per the judgment Supreme Court, in the absence of disobedience, my lords, absence of disobedience, Order 39 Rule 2 shall not be applicable.
Definitely, implementation needs when there is a there is a disobedience.
No, my lords, before the child court passed injunction order 2015, we were
Whether this injunction order still in force, that is in force.
Yes, ma'am.
Then what remains? What is there is nothing wrong in it. We do not see anything wrong.
Injunction order is still in operation, my lords. There's no dispute about that. But my shop has been disclosed, my lords.
That you can go to other remedy. If you say that they have exited, that is not just for this divisional court to go and determine.
And also, my lord, the affidavit I have bring on record.
Where is the provision for implementation of injunction? Order 39 rule?
2A, sub rule 2. Yes.
Yes.
No attachment under this rule shall remain in force for more than.
There is no.
Shall remain in force.
Where is? Yes. There is no attachment has been made. And if you say that this attachment has been made, it will not remain in force in 1 year. And if you say 1 year is gone,
Yes, ma'am.
then also it's over.
And also, my lord,
Where is the attachment? Where is was there any order of attachment here?
just
What is the report of the OC after this order? Just give us. What is the report of the police?
also, my lord, the affidavit. First of all, let me make first mention is that the affidavit I bring on record passed by trial court in the 7th of 6, 2024. The keys, my shop has been closed by this order. My shop has been closed, and the keys are in the custody of the police. And after that, they
See, there is basically after this order,
Yes.
by which police was directed to implement the injunction order.
Yes.
What is the report of the police thereafter? See, there is a direction to the officer in charge to furnish a report.
Yes,
We want to see that report.
Can you see that in my affidavit, my lords?
That report has been enclosed.
That's a report where the keys are in the custody of the police.
We are not about your statement. We want to see that report by OC.
That's the order. We have.
What is the report by OC?
There's no report from the OC, my lords.
No report has been submitted. Are you taking that stand? Are you sure?
Yes, my lords.
Yes. Is it correct that no report was submitted?
Your Lordship, they have brought on record, Your Lordship, this order dated 7/6/2024.
Where is that?
It's affidavit on record.
There is order by
Passed for child court, my lords. Can you see the type copy?
7/6/2024. Yes.
Page 6, Your Lordship.
Page 6 type copy.
Seen the compliance by the police.
In the shop.
Yes.
It's not operationable and close will apply to direct the police in charge and Canton House to follow up the matter. Also seen petition 490/24 filed by the petitioner praying for releasing the original keys of the shop 81F, which was seized by the police to the petitioner. Heard both parties, petitioner, the bench assistants to hand over the original keys to the shop number 81F to the plaintiff, my lords. So after,
If it is given to a plaintiff,
yes, my lords.
does it remain under attachment? Attachment is what? It will not mean this custody of the court or any person authorized by the court to hold it on their behalf. It is given to party.
Yes,
What is the
ma'am.
question of attachment here?
My lords, both of us are in possession of this suit shop, my lords.
How we can decide who is in possession? Where is the police report?
This is this compliance report, my lords. I've been illegally dispossessed of my property, my lords, during the pendency of the suit.
Whether this order dated 7/6/2024 is under challenge?
Which one, Your Lordship?
Challenge is order dated 7/6/2024.
We have still in our petition there was there was a mini execution. That's why we have still in my petition it's a
But
mini
then this
execution.
order is not under challenge. There is the order by which key was handed over.
This order arises from the impugn order, my lords.
Impugn order doesn't say hand over key to the plaintiff. Impugn order says that the injunction to be followed.
Yes, my lord.
The subsequent handing over basically is by this order. So that is not under challenge. What is the question?
And
This is order of 2024.
Yes, my lord.
Your Lordship,
More than 2 years now.
That time the appeal is still we have filed an appeal.
Your Lordship, what
Still
happened is,
pending.
Your Lordship, is the respondent, we have got the injunction order, Lordship. Then it became obsolete in 2019. 2015, we got
Injunction is which year?
injunction order 2015, Your Lordship, interim, we got
But then,
insolvent.
my God.
Then for 3 years, they have not filed any reply or show cause. Then they came to vacate that interim injunction, which the court has made it obsolete, Your Lordship. Now what happened, Your Lordship, during the pendency, Your Lordship, the petitioner, one of the shopkeepers is a non-tribal, where the shop has been leased. Then what she has forced him to hand over the keys and at the same time to pay rent to her. Then we have filed an application in the court, bringing on record. So what happened, Your Lordship? The court has directed to implement this interim and absolute injunction.
You know, the time when this injunction order was passed,
Yes, Lordship.
what was the situation so far as the shop is concerned, shop room is concerned?
We are under possession, Lordship. That has been reflected in
You were
order.
under possession means like in which way? You were under construction possession or you were directly possessing it?
We are collecting the rent of both the shop, Your Lordship.
No, no.
But one of the shop,
We are
after
There
getting...
are two shops.
Yes, Lordship.
One is admittedly with you.
Yes, Lordship.
And the
You
other
both-
one,
you both, Your Lordship.
other one which is disputed
Yes, Lordship.
in this suit, you want to say that it was under your possession.
Both are
At
with
least
us.
the injunction order has ensured that it remains under your
Yes,
possession,
sir.
isn't it?
Now,
And then-
now in the when the injunction order is unoperationable, Lordship, the petitioner went to harass the shop owner. Then what he has left the shop. Then she took the key because the shop owner has.
No, but then if it is in your possession, how they will go and take the key?
That's why, Your Lordship, you file application in the court, Your Lordship.
The fact that I've been collecting rent from this
No, Your Lordship.
the fact that I've been collecting rent from this 81F of the shop
One
shows
shop
that I'm in possession also.
One shop is a regular shop.
You have done it after passing of the injunction order and by force. That has no relevance. That will not add to merit of your case.
Your Lordship, what happened?
If it is before, then definitely.
One shop.
But then, so long if the injunction order remains and if you have decided not to challenge it, where is the question yourself coming and raising that plea?
My raising the plea is only.
The injunction was passed in 2015.
Yes.
It was confirmed in 2019.
Yes.
Your Lordship, Your Lordship,
Good enough.
one shop is a shop, Your Lordship, one open shop, and the other one has been used as a godown, Your Lordship. That's why.
Anyway, see, we do not want to go into all those factual
Yes,
aspects,
sir.
and then we are not in a position
This
to
is a
determine that
revisional.
also. We are concerned with the legality and correctness of the
Yes.
order, nothing else. Now, it appears that there was an injunction order,
Plus, I have no.
and thereafter there is an allegation of violation of injunction. Police were directed to implement the injunction. Police
Hand over.
implements the court's order, and subsequently, by court's order, the key was handed over to them.
Yes.
Now, the order by which key was handed over has not been challenged.
Yes, sir.
And why should it be challenged here for the first time? You go and challenge it before appellate court.
Not challenging, just showing someone good. I've been illegally dispossessed. I've been illegally dispossessed during the pendency of the suit because as per.
Are you trying to establish your possession by contending that see the key was seized from me? That means it was under my possession. If that be the thing, you go seek vacation of the injunction order before the appellate court. Why you are here?
But my contention is to show, because as per Supreme Court judgment clearly states that defendant shall not be dispossessed when the plaintiff has not been able to prove his title, rights, and ownership over the property.
Exactly.
Now, the subject of ownership is still in
Now,
dispute.
whether you have been dispossessed or dispossessed, how do this court will decide?
I'm just showing.
How on what basis? Handing of key
Because
with
this,
the order which is not under challenge.
but this is a byproduct of the Order 39.
See, if you say that you are in possession, then you should have challenged the injunction order immediately. You have not challenged it. What it would mean? You are not in possession, you are not bothered.
Plus, I have no problem with the injunction order being still in operation, but I have but only
What is the
this
injunction order? What is the nature of the injunction order?
page number. Interim order is at page number 35.
Page number?
35. Interim
35.
injunction.
Now, when did you prefer this appeal?
Prefer this appeal. First appeal. After the after trial court passed in 2024. 2024, we have filed a first appeal in the first appellate court.
Now, you have not challenged this order dated 7/6/2024 before the appellate court also.
We have challenged the order.
What was your challenge before the appellate court?
My challenge is only for the breach of an injunction order.
My Lordship, if your Lordship has got page 40, your Lordship. Page 40 of the.
40.
Yes, sir.
Page 40 of the petition or
40 of the petition, your Lordship.
yes.
Yes, Your Lordship. Here, the schedule of property is reflected as the stall 81 and 82F, Your Lordship. The relevant portion,
Page
41. 41 schedule of the property.
Okay.
I'm reading, Your Lordship, page 41.
That is a part of the interim order.
Yes, Your Lordship. Now, what happened, Your Lordship? Now, I'll take Your Lordship to page 69, Your Lordship.
And what is the order passed? The petitioner being in possession of the suit property.
Yes, Your Lordship.
That is a clear finding. That is good enough. But more is needed. To what extent, see, page 40 you have seen. See page 40.
Yes, ma'am.
See the second paragraph. The petitioner being in possession of this.
This is an interim injunction. This is an interim
That
injunction.
is all right. But then this order has been passed on the basis of
This
court being satisfied they are in possession. And you have not, basically challenge that injunction order immediately. There is no challenge to this injunction order immediately.
This
That part of the matter remains.
this passed 2015, Your Lordship. Your Lordship, I take Your Lordship to page 69, Your Lordship.
Wait, just a minute.
Yes.
See, you are the very foundation, you are not touching the foundation of their case. You are trying to, do some sort of work on the top. If you, until and unless you go to the root, we cannot give you any relief. Even if you want to contend that, see, that key was with me, it has been taken over and all, that proves my possession, that also will not dislodge the finding recorded by the tribunal.
The fact that I'm taking a run from the shop shows.
That also will not.
Lordship,
Just because you have remained silent against the injunction. Silent against the injunction order.
Page 69, Your Lordship.
Page 69. You yourself have spoiled your case by not raising pleas in appropriate point of time. What is this? Yes, page 69. Yes.
Lordship, may I read, Your Lordship? Page 69. The Council of Appeals submitted that we have filed an application of 6419 regarding violation of interim order, Your Lordship.
So this is an order
Yes, Your Lordship.
dealing with the violation.
The violation, Your Lordship.
15th February 2019.
Yes, sir.
Now, when this injunction order was made absolute? When?
2019.
This the one, Your Lordship.
This is the order.
This,
The court has dealt with both the issue.
yes, Your Lordship.
The violation as well as.
Yes, Your Lordship. Because, Your Lordship,
Now, just tell us in brief. After you file an injunction application,
yes, Your Lordship.
along with the suit, did they file their SOCOs?
No, Your Lordship. That's why, Your Lordship, this is shown here, Your Lordship. Page 70.
They have to file their SOCOs.
However, in this case, more than 3 years has elapsed, but the matter was not heard, and they have not filed the SOCOs till 2019, Your Lordship.
They have not. They have not. They did not even file a SOCOs.
Back it also. No.
Good enough.
3 years.
Good enough. What more you want? you can put your entire report, but then you have spoiled your case there.
Also, my contention is let the injunction still be in operation, but let my shop be open back.
See, injunction order specifically shows the shop numbers. So, what is the question of accepting your prayer? These are the two shops. Injunction is with relation to those two shops. So why should we see now? You have not decided of to file a SOCOs. And this appeal was only against the order of
2024.
Both, Your Lordship.
this. See,
This appeal is order dated 12/9/2025, and this is the order of the appellate court, Your Lordship, and the order of the trial court 15/2/2019.
let us see what is there in the thing. Let's see the judge. Where is your petition where you allege the violation of injunction? Has it been?
Okay, my question.
Application violation? Yes. Page number 94.
Page 94, Your Lordship.
No, the suit was dismissed once for dismissed for default.
Was restored.
Now it is restored.
Yes.
And even the injunction order also was restored.
Restored.
When did you enter your appearance before the trial court?
We entered in 2007. We filed a written statement in 2017.
But then your government made in this revision application, paragraph 6 shows that the petitioner having knowledge of the order dated so and so filed a show cause in 2019. So do you want to say that this you were not at all aware?
No, this is just the. If I'm not mistaken.
And in paragraph 4 says that petitioner has defended entered appearance, but then respondent failed to appear. So is it not you are taking contradictory stand? You appear in one matter and you say that you do have no knowledge of that. You should be careful in making contradictory statement.
Your Lordship, this case was handled by another previous. They have taken over the case only in 2024.
That is we understand. You see, I do not mean lawyer.
Yes, sir.
The court has nothing to do with lawyer.
Yes, sir.
It means his party.
Yes, sir.
If he has to bear with anything,
yes,
that is his party. Okay.
Yes, sir.
So this court has nothing personal against the council. He is doing his best and he is supposed to do his best. But then this is a petition preferred by him, isn't it?
Yes.
So see how you correlate the statement between paragraph 4 and paragraph 6. Paragraph 4 says that he entered as defendant the appear and then you defaulted in appearance. And paragraph 6 he says that on having knowledge of the order so and filed show cause in 2019. So, only in 2019 he files a show cause.
Yes. 2019.
And that too also that statement precedes with the thing that on having knowledge of the order, thereby giving an impression that he came to know about this order in 2019.
Yes, sir.
Can it be believable? When he paragraph 40 says that he entered appearance.
We entered appearance in 2017. We have filed a written statement in 2017.
Do you want to say your entrance was for nothing? And you did not gather any knowledge after you entered appearance? This kind of argument will not last, actually. There is no question of raising. The council should not raise this kind of unsustainable things, arguments. Your entire petition, we do not find anything that you did to get this order vacated, interim order to get vacated. There is not even a single effort. And the injunction order make it clear that this injunction order was in relation to these two shops.
After the court has passed made the injunction order absolute, we have filed show cause on that, and then we have to vacate. It was rejected. So we never filed an appeal.
See, if the fact remains that injunction order is in operation from 2015.
Yes, ma'am.
So, even after it is made absolute, you have not filed any appeal.
No.
Your appeal comes only after?
After the breach.
To which way we should see it? When did you enter appearance before the court? What date?
We have filed a written statement.
You have not mentioned it in your thing. You filed your written statement in 2017.
Yes, page number 42. Yeah. On the 13th November 2017, we have filed our written statement.
Page 42.
Page 48. 48 is the last page of the written statement. 48 is the last page of the written statement. That is 13 November 2017.
No, you are referring to which page now?
35. No, it's 30. 42.
42 of your petition?
Yes, ma'am. That's the written statement we have filed.
No, when did you enter appearance, we are asking you, before the trial court?
For trial. This for
The
trial
court is asking you one question, you are giving reply to another thing. We are asking you, when did you apply? When did you enter appearance before the trial court?
I have no knowledge, ma'am. But we have filed a written statement on 2017.
What is the ground you have raised in this revision application?
There's a maintainable, there's no cause of action. My lords.
There is no ground in your revision application.
No ground.
The only ground which appears to be taken in paragraph 13 at page 5. That the order has caused prejudice to you and the respondent was allowed to take possession. Now you want to say all the orders are marched with order dated 12/4/2024, and if we interfere with this order dated 12/4/2024, all the orders will stand vacated.
No, but it's because the first appellate court dismissed on that grounds, my lord, that we have not filed any appeal.
So you took a very clever stand, isn't it? So that you do not have to answer the question of limitation, delay and lectures, isn't it?
No, my lords.
Very well thought. What do we do with this? You have not challenged this order dated 7/6/2024. You have never challenged this injunction order, nothing. Even if we assume that you were in possession and you have been dispossessed by after passing of the injunction order, in your absence to any challenge, in your absence to make any challenge to all these orders, this will not stand. We are revisional court.
Yes.
We cannot go into the facts. We have to see whatever is there in the papers. Paper doesn't say that you were diligent in resisting their plea. Nothing, nowhere.
My lords, regarding sub-rule 2, regarding the attachment, my lords. Sub-rule 2.
Attachment. What is attachment?
My shop was in.
You are trying to say it attachment. Where is the attachment?
Attachment and police came.
No, police.
Keys.
No more. Once it is released to somebody, attachment doesn't remain. Attachment is something, you see, like where it remains in the position of under control of somebody, isn't it? Who is not the owner.
Yes.
Or who doesn't claim to be owner. Here it is not. Here admittedly by order dated 7/6/2024, key has been handed over.
Yes. I believe that's the.
So that is that. Even if you say there is attachment, then attachment order doesn't remain, doesn't survive. We are, first of all, we are not accepting your submission. There was an order of attachment. But then, even if you say that yes, if there is any attachment, that plea also will not stand in view of the passing of the order dated 7/6/2024, by which possession was given to him. So that means the attached property was released. So that clause 2 will become inoperable now. 1 year will not be in operation.
So, but since the subject of ownership is in dispute, I believe the trial court made an error in giving the keys to the plaintiff during the pendency of the suit.
Maybe you challenge that order. You have not challenged.
This is a byproduct of the order 39 laws.
You have, that this court will not give you any opinion into this thing. Court is not your legal advisor. So whether you have not challenged this order, so we are not going to, if you say anything about that order when it is not under challenge. Rather you have brought in this order as to show, or rather contradict your own stand about this attachment. This order will contradict your stand of attachment. Mr. Lindo, what shall we do?
Pass necessary
You have argued very well. You have done very hard work also. But then your party is not at all. They have not taken step properly. A situation which has remained there for last 10 years, this court would not like to disturb it on these grounds at least.
Since we have closed the shop, and as per the allegations that collecting rent is a violation. Now close the shop. There'll be no more violation. So obviously this order 2A will cease to be operable. As per my understanding.
Just say it
as per
again.
my understanding.
Just again say. This
Since
court did not follow.
as per the allegations that we have violated the injunction order because we collected rent. Now shop has been closed. There's no more. We cannot collect rent anymore. So obviously, to order rule 2A will cease to operate. The breach. There will be no more breach.
Yes, all right. So,
Because
see, so far as the breach part is concerned, order was passed and order has been acted upon. The breach part is closed. We are not reopening it.
before the breach was still open. Now let it go back to where it was before.
No, this matter will definitely. See, injunction has been finally decided, isn't it? The suit remains. Or the court, so far as the merit of the case is concerned, that will remain. This court is not going to touch it. That will remain as it is. Your opportunity to contest and defend your case, that is always there. But the situation which exists as on today, we are not disturbing it.
Even when I've been illegally dispossessed.
That is you are terming it. We do not see that.
Handing over keys to the
We do not
plaintiff
see
shows that.
But then you have not challenged that order. Why you are again harping on certain thing which you have not done? This injunction was in their favor, admittedly right from 2015. Then suddenly 2025 you chase away his tenant. You put them under fear.
No, that's not true.
Put it under lock and key, and then take the key with you. This is a violation, clear violation. And we will say it because you have not resisted their claim. There has to be a basis. You see, you must know what stand you have taken. I can understand your concern. See the plea raised by you. But then the materials on record do not support it. If you were at all in possession, what you were doing last 10 years from 2015? Here was a reply, acceptable reply. You may claim that the key was with you, but the court's order doesn't say so. So we will not know. If thereafter at all any lock is put, you have done it by force, and court has rightly dispossessed you. If somebody violates injunction order, court has the right to do that. And there was no attachment at any point of time. What you say, we do not agree that. Only the service of police was availed to implement the injunction order.
But Manas, I believe that the keys should be in the custody of the court, Manas.
That will amount to attachment. Which you say illegal, now you want it. Enough. Do you want to argue one more day?
No, Manas.
You've given your best, but then. This order was passed on 12/9/2025.
Yes, Manas.
And when did you file this application? Almost after 1 year.
Yes, Manas.
Isn't it? There is no time limit fixed in Rule 6.
Yes.
No, we have made it read with rule section 105 CPC. See your cost title of your petition.
Yes, ma'am.
Read with section 115. Is it correct? Your cost title of your petition, revision petition, the very first heading, an application under Rule 6 of the High Court. You have seen that?
Yes, ma'am.
And does it say read with Rule 115 CPC?
Yes, ma'am.
So if CPC, if you bring, what is the period of limitation? 90 days.
Yes, my lord.
Then, anyway, heard. Mr. Linda, learned counsel appearing for the petitioner, and also Mr. Karim learned. There is only one respondent.
Yes, Your Lordship.
Learned counsel appearing for the respondent. Sit down, sit down. The fact of the case, in brief, is that Psycho, you can गलती नहीं करना है. Okay, just I may commit also, but then just be consistent. The fact paragraph का बाद में you just must know where paragraph comes. Okay, heart so and so and so. Okay, then you say by this revision application, by this revision petition, comma, the petitioner has assailed the order dated 12/9/2025. Now you have not made any challenge to the order of the trial court also.
No.
Which order was?
The order which you challenged in your appeal. The order, the trial court's order dated 12/1/2024. That is not under challenge here in this revision.
That was dismissed. We have filed an appeal on that one.
That is okay. Now you are challenging only the appellate court's order.
Yes.
Now if we interfere with the appellate court order, will it automatically mean the trial court order also goes? Anyway, just order dated 12/9/2025.
Was the was already.
It's all right. It's all right. What you have done, you have done. We cannot change it. Passed by the judge, Kuma District Council Court, Shillong, in MISC Civil Appeal number 7 of 2024. What is that? MISC case number 106?
Yes.
MISC case number 106. MISC case number 106 before trial court. 106 of 2023. Was it there?
Yes, ma'am.
This is a violation petition. You have seen the date of date and events we have attached. Only one date.
This is the copy of the miss appeal.
Do not know. This is only your list of dates only speaks about only one date, and that is the impugn order. So that is the only event. Okay, this is okay. It's all right. All right. It's all right. Paragraph. The brief fact of the case is that the respondent as plaintiff instituted title suit number 26 of 2015 for declaration of right, title, interest and permanent injunction. What is the suit property? In respect of the suit property. It's okay. Stop. The said suit was presented. Said suit was accompanied by Miss Case number 19 of 2025 for grant of ad interim injunction. Stop. The case was filed before whom? Which court? It was presiding officer.
Presiding officer, Your Lordship.
We just say respondent instituted title suit number so and so before the presiding officer SDCC, Subordinate District Council Court, Shillong, for right title. ठीक है? All right. After full stop, you just say the learned trial court granted injunction by order dated 23/12/2015. The petitioner thereafter entered appearance before the trial court and filed written statement on 13/11/2017. We are going by what you have said in the petition. If there is a mistake, then that will be your mistake, not our mistake. However, no show cause was filed against the miss case number 19/2015. Stop. Subsequently, the interim order was made absolute by order dated 15/2/2019. Now, what do you say again that you filed a show cause in 2019?
Yes, my lord. Page.
No. This is not an application for vacating the interim order. This is a show cause to what?
To the injunction, my lord.
Injunction was disposed of. It was made absolute by order dated 15/2/2019.
Yes, we have filed show cause on that. After.
Thereafter, you filed the show cause.
Yes.
And it was dealt with by the trial court.
Yes, my lord. Page number 71, my lord. Can you see? 71. 71.
Just what is the last thing? Stop. It appears that the petitioners sought vacation of the interim order dated vacation of the order dated 15/2019 by filing a petition the after subsequently, you said subsequently this order was made absolute, isn't it? Now you just said thereafter. Thereafter the petitioner filed. Thereafter it appears on the record that the petitioner sought for vacation of the order dated 15/2019 by filing a petition. Stop. The respondent filed objection. What we said, the previous line, the petitioner filed an application. By filing a petition, you make it by filing a petition stroke show cause. By filing a show cause, just say filing a show cause dated 14/5/2019. 14/5/2019. These dates you will get in paragraph 6 of the petition. Okay, acha. Then the file objection to the said show cause. Stop. The London Trial Court, by order dated 19/4/2022, rejected the prayer of the petitioners for vacation of the interim order. Stop. Afterwards, comma, the respondent filed an application registered as Miss Case number 106 of 2023, alleging violation of the injunction order and the London Trial Court, by order dated 12/4/2024, 12/04/2024, directed the officer in charge to ensure implementation of the injunction order and file a report thereof. Stop. Against the order dated 12/4/2024, the petitioner preferred an appeal registered as missed civil appeal number 7 of 2024 before the judge, District Council Court, Shillong. Stop. They said appeal was dismissed by order dated 12/9/2025. Stop. Being aggrieved, the petitioner has preferred this revision petition. Stop. Mr. Lindo, London Counsel for the petitioner. Primarily contended that the London trial that see, what is your challenge to the appellate court's order? All your contention has been raised against the trial court order.
Yes, Manas.
What is your challenge to the appellate court order?
That there was a mini execution, Manas, because police came.
Appellate court did not order any execution. It is a trial court.
Trial court. We have challenged that order before.
But then which way appellate court failed? Just say.
No, it's not.
See, that is your challenge to the trial court's order.
Yes, ma'am.
That a mini execution has been ordered.
Yes, ma'am.
But then, why this appellate court order is bad?
Can you see page 142?
Just tell us the ground why appellate court order.
Because we have not filed an appeal on all those 2015, 2019, so they have failed to consider them.
Anyway, it's okay. It's all right. What you said? That by passing the order dated. This is 12/9/2025, isn't it?
Yes.
That is what you are saying, execution.
Yes. Yes.
Is it?
Yes.
Okay. By passing the interim notice also, the London Trial Court has, in fact, allowed the attachment of the property. Stop. He submits that the petitioner was dispossessed illegally. Petitioner was dispossessed of the suit premises illegally on the basis of the order dated 12/9/2025. Without following the due process of law. He submits that. He submits that the passing of the order has caused serious prejudice to the petitioner. What is it? In message, if there is any breach of injunction, and breach of injunction resulting in attachment of property, such order cannot remain in force for a period of more than 1 year. And in that view of the matter, the suit property, in that view of the matter, the petitioner is entitled to get back the possession of the suit property. He submits that the London Trial Court. Further, the trial court by order dated 07/06/2024, a copy of which has been brought into record by an additional affidavit, has handed over the key of the disputed suit premises to the respondent. In total abuse of process of law. Stop. The learned counsel further contends the learned counsel further contends that the appellate court has also miserably failed to appreciate the provisions of law in its proper perspective and has wrongly rejected the appeal filed by the petitioner. Stop. He therefore submits that the impugn order dated 12/9/2025 of the appellate court is not tenable in the IF law, liable to be interpreted. Stop. Mr. Karim, learned counsel, on the other side, vehemently resisted the submission advanced on behalf of the petitioner and submitted that the injunction order against the petitioner is in operation from 23/12/2015 stop. He submits that the order was further made absolute. The order was made absolute. Do not say. The order made absolute by the trial court on 15/2/2019 and against confirmed by order dated 19/4/2022 when the learned trial court rejected the prayer of the petitioner to vacate the interim order. Stop. He submits that none of the above orders were ever challenged by the petitioner. Ever challenged by the petitioner before the higher court, before any higher forum, and hence, the petitioner as such cannot raise any grievance against the implementation of the injunction order. Step. He submits that the respondent was constrained to file an application. Constrained to file Miss Case number 106 of 2023 before the trial court because of the violation of the injunction order by the petitioner and thereafter in terms of the order dated, in terms of the order dated 12/4/2024, comma, with police assistance, comma, the injunction order could be implemented. Stop. By referring to the order of the trial court, comma, the Lorded Council specifically contends that the detailed identification of the property in relation to which the injunction order was passed, comma, had been properly described in the order. Stop. He submits that since there remains no confusion with regard to continuous possession, there remains with regard to the continuous possession of the respondent and passing of interim order in his favor, comma, the revision, the instant revision petition preferred by the petitioner has no merit and liable to be dismissed. Paragraph. Say, upon hearing the learned counsel of the parties and on perusal of materials on record, it appears that the London Trial Court, by order dated 23/12/2015, granted an interim injunction in favor of the respondent and since then the said order is in operation without any interruption. Stop. The case record reveals that the petitioner has never tried to put, was never serious. Petitioner was never serious in challenging the said interim injunction order, as he declined to file any objection against the prayer of the respondent for grant of injunction. If there is any repetition of any word in one sentence, just to cancel it. You don't have to mention it twice. What is it? They failed to file. Despite filing a written statement in the suit on 13/11/2017. The first challenge against the grant of an interim injunction was raised by this also by the respondent. What is it? The first challenge? No, the first challenge by the respondent against the grant of injunction. Case came to be lost only on 14/5/2019. Which, however, stood rejected by order dated 19/4/2022. The record, despite such rejection, the record reveals that no appeal was filed by the petitioner against the order. It is only after passing of the order dated 12/4/2024 in Miss Case number 106 of 2023, wherein the landed trial court issued direction to the police to ensure implementation of the injunction order. The petitioner filed Miss Civil Appeal number 7 of 2024. The grievance of the petitioner that then used the petitioner that he was disposed of, he was dispossessed of the suit property because of the order dated 12/4/2024. You just do not say grievance, you just say contention of the petitioner that he was dispossessed and disposed of the property because of the so and so does not appear to be correct in view of the fact that the injunction order, in view of the operation of the injunction order for a long period of time. Stop. The further contention, the other contention of the petitioner, that the implementation of the order, injunction order by the police, amounted to attachment of the property and should stand released by operation of Order 39, Rule 2A, Subrule 2. Order 39, Rule 2, capital A, then within bracket, Subgroup 2. CPC. Also does not appear to be appealing as the order of the trial court, as the order dated 12/4/2024 did not make any specific order of attachment of the property and to keep it under authority of any receiver. Stop. The order, the relevant part of the order only projects issuance of direction, only shows issuance of direction to the policeman, to the police personnel to ensure implementation of the initiation order. Stop. Such an order cannot be termed as an order of attachment by any stretch of imagination. Stop. The conduct of the petitioner, S can be derived from the facts and events narrated in this revision application. Projects that he was never in possession of the disputed suit property after order dated 23/12/2015 of the trial court. Stop. Paragraph. In view of the further, just paragraph, just further. The perusal of the order of the appellate court also doesn't show commission of any jurisdictional error, as there is no instance of consideration any material which is not a part of the record. Stop. There is also no example of any perversity in the observation and finding recorded by the appellate court. Stop. Paragraph. In view of the facts and situation, in view of the above facts and situation of the case, the petitioner has failed to make out a case for interference. Stop. Hence, this revision application is devoid of merit and stands dismissed. No cost. You have done very well, Mr. Lindo. Your argument was good. Raised pertinent points, but then your action did not support those points. We'll do one thing. Just for his satisfaction, just say, before parting with the record, it is made clear that this court has not gone into the merits of the claim and counterclaim of the parties. Stop. The learned trial court shall not get influenced made by the observation made above. And decide the matter in accordance with, strictly in accordance with, and decide the matter strictly in accordance with merits. At least he should get something. Yes. Yeah.
Okay.
There may be some correction here, there.